Good afternoon. Welcome back. Glad to see everyone looking well, and I hope you have been. Welcome, of course, to the Appellate Division, First Department. We have almost 5.5 hours of argument this afternoon, so please keep that in mind as I call the calendar, and please ask only for the time that you'll absolutely need to make your arguments. Remember that we have your record, we have your briefs, we are fully familiar with the facts of the cases. First case is People versus Benjamin Lanzott. I'll give you 5 and 2 and 5. Thank you. Maynor versus Millennium Medical. Anybody else here? Is the respondent here? It appears the respondent is not here. Do you wish to submit?
This is my first time before the court. I'm sorry. I do have to argue.
Okay, I'll give you 2 minutes. 2 minutes and a submission. And welcome, since this is your first time here. Adam M.N. versus Dara D. is submitted. Kamamalov versus Popik. Now, I'm just going to ask you, did you want one for rebuttal, or you just want your 5 minutes? And keep your mask on. So you want 5 and 2. 3 and 2? Okay. Okay. 3 and 2 and 5. Okay. DaCosta versus New York City Department of Buildings.
Good morning, Your Honor. Appellate request 12 and 2.
I didn't hear you?
7.
7. Okay. I'll give you 6 and 2 and 6. CBG Genovic Management versus Massachusetts Bay. I'll give you 5, 2, and 5. Friedlander versus Jack's Holding. Is the respondent here? Sorry, I didn't see you. 5, 2, and 5. People versus Jesse Smith is submitted. Gorman versus Gorman. I'll give you 6, 2, and 6. Pye versus Reliant Transportation. Is the respondent here? Okay, if both parties would stand at the same time, then I'm not going to be asking these questions. Appellant, yes?
Appellant request 5 and 2, please, Your Honor.
5, 2, and 5. People versus John Adderby. I understand the appellant is running late and asks for 4 and 1. You must be the respondent? Okay, 4, 1, and 4. Let's see if they make it here by argument. They have told us they will argue. Liberty Mutual versus Jenkins Brothers.
Good afternoon, Your Honor. Appellate requests 9 and 3. Respondent requests 9.
I'll give you 7 and 2 and 7. People versus Darrell Stephen is submitted. Leong versus Madison Street.
Good afternoon, Your Honor. Appellate requests 6 and 2. And respondent requests 7.
5 and 1 and 5. 514 West 44th Street is submitted. Borsheim versus the City of New York is submitted. First case for argument is People versus Benjamin Lanzott.
Good afternoon, Your Honors. Victorian Wu, Office of the Appellate Defender for Mr. Lanzott. The plea arrangement in this case was extremely unusual, and it raises 3 issues on appeal.
Counsel, let me just, I'm sorry, I'm going to get right to it. One of your issues is that your defendant pleaded guilty under duress, but are these issues preserved? Did your client, the defendant, ask to withdraw his plea?
Mr. Lanzard did not formally move to withdraw the plea, but our position is that there were sufficient circumstances presented to the court below that a further inquiry was warranted in accordance with Court of Appeals cases like People v. Lopez, People v. Francis, and others which I have cited in my briefs.
I think that at sentencing, and I hate to jump over to that, but at sentencing, I think the defendant asked, well, is there any way I can reduce my plea? Nobody said anything. No one answered. I mean, that was an opportunity for counsel. It's not the court's purview, but counsel could have said something right there, and nothing was said. So how is that not waived?
No, so what counsel relayed to the court was the fact that Mr. Lanzott had a discussion with counsel about withdrawing the plea, and Mr. Lanzott wanted the court to know that there was such a specific discussion. So that was Mr. Lanzott's attempt to reach to the court and ask for the court to protect his rights. This case is very similar to one of the companion cases in People v. Nixon, a Court of Appeals case that I cited in my reply brief, where similarly the defendant at sentencing made statements that questioned his plea. He didn't formally move to withdraw the plea, and at sentencing, the only advice that his attorney gave was to listen to the judge.
So what was the basis of this, even raising it? What was the basis here?
So the basis are the bases that we're raising on appeal, that the plea was obtained under duress.
But how is that? I mean, because of his health conditions, because he was permitted for months to get the kind of health care he needed. I think he was treated for cancer, for a stroke. He was found to be in far better health.
Well, at the time that counsel was asking for the prosecution's consent to transfer Mr. Lanzard to a nursing home, he was actually deemed to be seriously physically ill. His treating physician at Rikers was recommending that Mr. Lanzard be transferred to a nursing home, and I think it speaks volumes that the treating physician at Rikers made that recommendation. What was problematic here was that the prosecution acted in defiance of that medical advice by refusing to let Mr. Lanzard transfer to a nursing home
But he was
for more than a year.
at the nursing home for months. In fact, he was transferred to a different place so that he could be properly treated. Then they lost track of him because he had had a stroke and he was transferred to yet another place. So he was treated and then returned to a nursing home at some point.
He was never in a nursing home before he pled guilty. That was the medical recommendation. He needs to go to a nursing home. The prosecution refused to let that happen until Mr. Lanzard changed his plea.
I'm sorry,
to a
counsel,
plea of
why
guilty.
would that be a basis to vacate the plea because a doctor suggests that he needs to be in a nursing home? No promise certainly was made by the court or the prosecution that he'd spend the rest of his life in a nursing home, correct?
No, but it's fundamental that a plea entered out of desire to protect your own physical well-being cannot be deemed voluntary.
But
in our legal system.
may I just ask,
Yeah.
this what you're saying that the doctor said about the nursing home, was that said at sentencing or at the beginning when he took the plea?
This was stated in 2013 when Mr. Lanzard was getting ill and
When he
undergoing
took the plea.
chemotherapy.
It was when he was ill, when he was taking the plea. Am I right?
No, the
No?
plea was taken a year later. The prosecution refused to let
Okay,
Mr.
so
Lanzard go to a
the
nursing home.
question is this: was he still in the same condition a year or more later than he was when this was said? People's health change.
Yes, there's no indication that his health status had changed when he entered the plea in 2014. And I think the promise that was made to Mr. Lanzott was that he would be sent to a nursing home in return for his plea of guilty.
I'm sorry.
No, that's not accurate. Counsel, I have a question for you because
Yes.
I was under the impression that the defendant was already in custody and receiving medical treatment when he pled guilty. Am I correct about that?
He did receive some medical treatment,
Uh-huh.
but counsel was asking for Mr. Lanzott to be sent to a nursing home.
Okay, I just
He
want
was
to
still
follow up,
very
if I
ill.
may,
Yes.
Justice Ringwick, because, although the people initially disagreed, I was under the impression that they did consent to the transfer once they obtained the medical records, because there was some question about the defendant's condition, but once they received the medical records, they did consent.
There's no indication in the record that Mr. Lanzott's health condition was miraculously better at the time of the plea. And in fact, I think what the record shows is that he was struggling with 33 medical conditions. Even at sentencing, the probation officer noted that Mr. Lanzott was paralyzed on the left side of his body, was in a wheelchair. And Justice Burke, before sentencing, said, "You are in serious need of permanent medical care." So there's simply a plea of guilty obtained in exchange for the possibility of going into a nursing home, in my position, cannot be deemed voluntary and should be vacated.
Thank you.
May it please the court, Victoria Muth for the people.
Counsel, there's something odd about this, because the defendant, this was a case where he was offered and attempted for 12 years. Then there was a Clayton, he rejected that. Then there was a Clayton motion. Clayton motion was to say dismiss the whole thing because of the extraordinary circumstances here, those circumstances being his health. And there wasn't addressed. The people didn't respond to it. The court obviously didn't rule on it because the people didn't respond. But then he pled guilty to burglary, I guess, with a 16-year minimum. Now, why would a defendant plead guilty to a 16-year minimum higher than the first attempted where he could have gotten 12 years when there's a Clayton motion pending? And then at that point, he was going to be permitted to go to the nursing home. Doesn't that seem to indicate that what the defense counsel is saying about the fact that there was some agreement here that he would be able to go to the nursing home and then remain there? Is there something else that's going on here that was going on behind the scenes?
As far as the Clayton motion goes, the record certainly leaves a lot to be desired in terms of why the court never ruled on that or why the people never submitted a response. But the people's position from the very inception of the case was always the same. They made a one-time offer before defendant's illness was known, that they would offer a one-time offer to attempted Berg 2, and that they would not be making that offer again once they answered ready for trial. And far from being the product of coercion, defendant's plea was the result of the patient and zealous advocacy of his counsel. After we had learned that he had been receiving chemotherapy in Rikers for cancer, we consented to allowing him to go to the nursing home as soon as the medical records were received, and receiving the assurance from counsel that the nursing home that he would be transferred to had the structure in place to be able to appropriately supervise him. Defendant's argument is that not receiving medical care at the facility of his choosing amounts to legal duress, and that's not the law. Defendant's presentation of the record is also inaccurate. He claims that the only way for him to get medical care was to plead guilty, and that simply isn't true. He had been receiving medical care since 2013, and we know that from the medical records.
I thought that the papers alluded to defense counsel and the defendant's belief that he would get better care at a nursing home than at Rikers Island. And everything I know about that issue would make that statement true.
That might be true, Your Honor, and that's why the people consented.
I point that out because that was the whole basis for his plea, that I want better medical care in order to improve my chances of survival. I'm sure that that was the reason for the desired care in a nursing home setting rather than at Rikers Island when doctors come on a schedule, not when patients require their care.
And that's why the people consented to allow him to go to the nursing home. But it is not the case that under every circumstance, any defendant is allowed to medical care of his choosing. It's a case-by-case basis, and we allow defendant to go receive that care here. And defendant's doctor
Was,
never said
at the
that
time of the plea, was there a plea agreement stated on the record other than that he was going to be pleading to the second-degree burglary and satisfaction of the entire indictment?
both defendant's counsel and the court detailed what the sentencing range was that he would be receiving, and the court stated to defendant that he was to remain there under certain conditions, including the condition that he not leave the facility unless it's for medical reasons and with permission pursuant to a court order, and that his sentencing would, quote, be adjourned until such time as further application.
And it wasn't that he was released pending sentence to the Bronx, Lebanon nursing home?
That's correct, Your Honor. And his doctor had never said...
But does that mean that he was going to be then allowed to stay if it's pending sentence to the Bronx, Lebanon? You just said that was correct.
It was never promised to defendant that he could remain there forever. It was pending sentence while he convalesced there.
Okay,
Unless there are any further questions, we ask that you affirm. Thank you.
thank you.
Just to quickly clarify, the prosecution did consent to the transfer, but they did that only after Mr. Lanzott agreed to plead guilty. That was the quid pro quo. You plead guilty and we'll consent to transferring you
But
to the
counsel,
nursing
you didn't
home.
answer the question I asked before. Was there ever a promise that the defendant would remain in the nursing home for the rest of his life?
That was never specifically stated at the plea, but I would note
So
that
isn't it reasonable then that once he got better, he would be moved?
I would draw this court's attention to the May 10, 2016 proceeding when Justice Burke was the new judge on this case and tried to get up to speed. And he basically asked the parties for background. He said, I'm trying not to be insensitive, but did everyone expect him to die in his treatment facility? Defense counsel stood up and said, you're not being insensitive, Judge. That was the expectation of the parties. We never anticipated that we would have a discussion about sentencing because that was how ill Mr. Lanzott was at the time of the plea. The prosecution never objected to any part of that presentation when defense counsel was trying to bring Justice Burke up to speed on the case. So that was the circumstance in which the plea was entered. All the parties expected him to die in the nursing home because he was so ill. And the record makes clear, as Justice Manzanetti, you pointed out, Mr. Lanzott told probation prior to sentencing that he, quote, admitted guilt because he was in need of medical care. That was the reason why he pled guilty. And simply put, a prosecution should not be allowed to get a plea of guilty from a defendant in order to consent to him getting the health care that he needs. That kind of quid pro quo is unacceptable in a civilized legal system and should be vacated by this court. Thank you, Your Honors.
Thank you. Maynor versus Millennium Medical.
Good afternoon, Your Honors. May it please the Court, Jeffrey Schuman of Fort Harrison on behalf of defendants/appellants. Very briefly, Your Honors, the release that the main plaintiff in this case, Tanya Maynor, signed is completely valid, and there's no contrary evidence. There's no evidence to the contrary. The plaintiff, Maynor here, was paid $12,500 to release all of her claims, past and future commissions, and this was a validly entered into release. The only time where the plaintiffs had contested the illegality of the brief is in an opposition brief. We filed our first motion, defendants filed their first motion to dismiss in May of 2020. They were then on notice that we were
Did the
making this
plaintiff
release.
here have a salary outside of this commissions-based structure?
I'm sorry, I didn't know the first part of your question, Your Honor.
I said, did the plaintiff here have a salary outside of this commission-based structure?
I believe so, Your Honor, yes.
Okay, so this was above salary?
That's correct, yes.
Okay.
So the plaintiff is basically trying to accept the money and reject the condition, as one case put it.
So, counsel, let me ask you this. In the complaint, the plaintiff alleges that my understanding when I signed that release was that I was getting paid commissions on the gross, and that I later found out I was getting paid commissions on the net,
On the net.
which would be, if that was true, and she was told gross and was getting paid net, a good claim to invalidate the release on the basis of fraud. No?
I don't think so, Your Honor. I'm sorry, I see my time is up. May I answer your question?
Yeah, I
Yes.
mean, that's the plea. We're at the pre-answer motion to dismiss claim. That's the claim that you misled her. You told her gross, and you took the commissions on net. How is that not at least a sufficiently pled fraud in the inducement of the release claim?
Your Honor, it's not sufficiently pleaded because it first came up in an opposition brief, and you don't have to accept that as true. You can accept the fact in the complaint that it's true, but she doesn't, there's nowhere in the complaint the word fraud, in the amended complaint, the word duress, the word mutual mistake. That's nowhere pleaded anywhere. And I'm not suggesting that plaintiff has the burden to disprove an affirmative defense. I understand that. But
But I mean, also mutual mistake, same thing. You don't have to plead that specifically. You may have to plead fraud, but you don't have to plead mutual mistake.
I agree, Your Honor. You don't have to plead mutual mistake, but
Why shouldn't we just accept that at least the complaint alleges that?
the complaint does not allege mutual mistake, Your Honor.
It alleges breach of contract, right?
It alleges breach of contract, but there's absolutely, all the complaint says, and I understand that this is a notice pleading state, correct? But all the complaint says is there is a contract. There has to be more meat on the bone than that.
Okay.
Counsel, I have a question. There is a case law in this department which suggests that under certain circumstances, releases like this could violate public policy. What's your response to that argument? That could this release violate our state public policy?
No, Your Honor, because this is, excuse me. No, Your Honor, because this is a case about the forfeiture of wages, which this court has held numerous times that releases for forfeiture of waivers when given in exchange for valuable consideration here, almost $13,000, do not violate public policy at all.
Thank you.
Thank you.
Thank you, Your Honors.
Kamamalov versus Popick.
Good afternoon, Your Honors. Joseph Tripodi on behalf of the appellants. I just want to briefly focus on what I think is probably the most important issue here. It's that the dismissal based on statute of limitations was a dismissal on the merits. The 2010 court, Justice Freed, made that very clear in his decision.
You would put your mask up, please. Thank you.
Sure. When Mr. Popick filed the 2011 action and reasserted that condominium claim in that case, Justice Cornwright dismissed the entire case on claim preclusion with respect to the condominium claim. That was correct, and this court affirmed that. And that is something that was absolutely lost, I believe, in the lower court here.
So you're saying, given that that was essentially the dismissal by Justice Freed, essentially a dismissal on the merits, that at that point there shouldn't have been a new action.
Absolutely.
It should have been either to renew or re-argue or amend or something.
Yes, Your Honor, that was the only course. So even apart from that.
Why wouldn't it be appropriate legal strategy to bring a new action?
I'm sorry, Your Honor.
Why would it not be appropriate just to bring a new action as legal strategy as opposed to a motion to renew?
Well, because it was a dismissal on the merits. So bringing a new action would have that condo claim barred under claim preclusion, as this court recognized. So it was not legal strategy, because legal strategy means there's two reasonable alternatives. Okay, and a lawyer can't be held liable for malpractice by exercising one of those alternatives. But when one alternative is a dismissal and the other alternative is a high likelihood of getting a claim reinstated, that's not judgment. That's not a strategic, that's based on judgment. That's all I have. If I could reserve for a rebuttal.
Yes, you have. Thank you.
If it please the court, Mark Anish, Louis Brisbois for Attorney Popick and his law firm. The record here clearly shows, and the judges clearly admit, that there was judicial error in causing this counterclaim to be, causing the condo claim to be dismissed.
Counsel, last time I looked, the court can't be sued for malpractice.
Right.
So the question really is, sure, there it looks like there was error here. But let's just go back to the beginning. Statute of limitations had not run. You still had probably 3 more years for the statute of limitations to run. Why not get the contract, knowing that if you don't have the contract, there's a chance that it's going to get dismissed on statute of frauds grounds on the merits? Why not wait to get the contract? I understand there are issues. What?
He had no idea when he was going to get the contract.
Well,
He only got it until after he started the action. And the action was not dismissed on the merits. Judge Freed had before him a 3211A7 motion. He did not have a summary judgment motion. And nothing in his decision says, quote unquote, it's on the merits. Judge Kornreich even said his decision is unintelligible. Judge Jaffe even said that dismissing the condo claim on the merits while allowing the artwork claim to go back and be repled makes no sense whatsoever. It was not on the merits. And as the case law says...
But that's because with the condo claim, there was no contract. There was no contract. There was no identity of the parties. So
Right.
it didn't...
There wasn't. But in the briefs...
it wasn't viable under the statute of frauds. I mean, that's why he dismissed it, that claim.
Yes, he dismissed it, but he did not dismiss it on the merits. If you read his decision, it doesn't say... He only had before him a 3211A7 motion.
No, but counsel, but the First Department said it was. Whether or not you agree with that, you're there. The First Department says we're dismissing it with prejudice, right?
No, the first...
The
No,
affirmance?
with all due respect, Judge Kornreich dismissed...
No, let's talk about Bernie Freed's affirmance.
Okay.
What happened there?
He dismissed the claim on a 3211A7 motion.
And what did
It
the
was
first...
not appealed.
And what, okay.
It was not appealed. Judge Kornreich,
Oh, right.
at the new action,
Right.
that was appealed, and both
sorry.
he and the appellate division, with all due respect, didn't pick up the fact that the contract was annexed to the papers.
Okay, but you are where you are, right? So you know now your only viable option is to go back to the first case action and make a motion to re-argue or renew, right?
Well, if you make a motion to re-argue, renew, the strategy, Judge Jaffe said the strategy was perfectly correct. If you make a
How
motion
could it
to-
be correct if dismissal on a statute of frauds claim is on the merits?
Again,
How could that be a good
Judge
strategy?
Freed's decision was not on the merits. He did not have he only had a pleading motion before him. He sent back for the same statute of limitations argument. Same. He sent back the artwork claim to be repled, but for some inexplicable reason, according to Judge...
Let me just start with you. Are you saying that dismissal of a statute of a claim on statute of frauds is not on the merits?
I am saying if you read the case law...
I'm asking you.
Yes.
You're saying it's
If it's not a 3212 motion, and there's no notice pursuant to 3211C, it's not on the merits. Someone has to say, either the court or one of the parties have to plead summary judgment. If it's a pleading motion, 3211A7, it's not on the merits. And it's inexplicable why he sent it back for the artwork on the statute of frauds to be repled, but he didn't send it back on the condo claim to be repled. And Judge Kornreich's hands were tied, she said. I mean, even she blamed prior counsel for their errors. She blamed successor counsel for their errors. Neither Jaffe or Kornreich blamed Attorney Popick in any way.
Okay, counsel, on this pleading, at this pleading stage, Can we say that the failure to renew as opposed to commencing a new action was a reasonable litigation strategy?
Yes, it was reasonable. I'll tell you why.
We're not at summary judgment stage, right? We're on
Right.
a pleadings motion. So
Right.
how are we to make that determination?
Because he had reasons why he repled. If he only did a motion to renew, he would have lost the artwork claim. Okay? He would have lost the artwork claim. That went out the window. The judge sent it back to replead the artwork
So doesn't it
claim.
sound that what we need in this case ultimately, when we do get to summary judgment, if the case survives, you'll have expert affidavits from both sides, where then the trial courts and the appellate division can make a determination.
Determination on what? Whether it was
As to
reasonable?
whether it was reasonable or not.
Well, Judge Jaffe, within her discretion, determined that his action was reasonable. He said,
That's for us to decide, no?
well, I think Judge
I mean, that's
Jaffe
what
already
we're
made
here
that
for, right?
Well, I think it's within her discretion to do it. If you think she abused
And you're
her
saying it's
discretion-
not within our discretion to decide?
I didn't say that.
Counsel, it would be nice if you would allow the judges to finish their sentences.
Thank you. Sorry, Your Honor.
I'm done.
Thank you, counsel.
Can I just make one other point?
I'll give you 30 seconds.
Documentary evidence in the form of a tax return that he signed, the plaintiff, said that he received full compensation for the condo claim. So that has been held by the courts as solid evidence, as documentary evidence to dismiss a claim where the plaintiff asserts something to the contrary.
Thank you.
Just briefly, I want to, there's no authority that distinguishes between motions to dismiss and motions to summary judgment when it deals with a statute of frauds. There is none. They haven't cited any because there isn't any. The only authority says a statute of fraud dismissal, even on a motion to dismiss, 3211 motion, is on the merits.
So, and counsel, was that dismissed on 3211A5, right? Not A7? I think that's what happened, right?
I believe it was an A5 dismissal.
A5
Correct,
dismissal,
yes, and
right?
it's specifically,
Which would not be failure to state a claim, but, right?
that's all I
Counsel,
have, Your Honor.
I'm sorry, before you leave, can you address the 2007 tax returns?
Oh, sure. The tax returns, there was an error. The accountant, there's a pending accounting malpractice action. The accountant included in the 2007 returns that the condo was sold for $4.1 million. In fact, the money was never paid. That was an error. He moved to,
But isn't the claim that your client got various objects, artwork, as I understand, in consideration for the sale?
my understanding is that was one of the arguments made below, and that's an argument that they can make here during the course of the case. That's certainly an argument that they can make as to whether payment was made or not. But in that particular case, that tax return was amended. In addition, the summary judgment in the accounting malpractice action was reversed. So there's no judicial estoppel effect. Thank you, Your Honors.
Thank you. Thank you both. DaCosta versus New York City Department of Buildings.
Good afternoon, Your Honors, and may it please the Court. Max Rodriguez for the plaintiff appellant, Dennis DaCosta. The key part of the dispute in this case is concerning the scope of Civil Service Law Section 75B and whether it protects former public employees from retaliation for whistleblowing during their employment.
This is the pleading stage, but I want to ask you how your client knows that it's the Department of Buildings that caused Health and Hospitals to rescind his offer. I mean, that's what he's saying, right? That he worked for, he left Department of Buildings, interviewed, got an offer, and then after they were doing a background check, they rescinded the offer.
Yes, Your Honor. The answer to that is that it's a reasonable inference which is acceptable at the pleading stage due to the fact that Mr. DaCosta was aware during his employment at the Department of Buildings that another attorney who had engaged in an investigation and submitted a report that the same supervisors viewed unfavorably, resulted in them, quote unquote, red flagging that attorney in the city's personnel system, which sent two messages to Mr. DaCosta. One of them was that they were willing to retaliate against people that did things they disagreed with at the DOB. And second was that some of those consequences that might come from that retaliation might be the ability to affect future employment at other city agencies. And so based on that prior information about the practices of his supervisors, it's a reasonable inference to infer, given the fact that, as he adequately pleads in the complaint, he was doing a good job and was well received in his job prior to this sort of escalation of conflict with his supervisors due to their attempt to stymie all of his investigations, which was his job, that it was reasonable to infer that the same thing happened to him after he reported the conflict of interest of his supervisors to DOI and ultimately to the law department.
And so now let me go back to the Civil Service Law 75B. That doesn't specifically state that you can do post-termination retaliation, so why do you believe you can move pursuant to that?
Sure. So the text, if you read it fully in context to ensure that all of the words are given meaning, it necessarily must include that this sort of retaliation claim is covered. This sort of retaliation claim referring to the sort where the disclosure that occurs during the public employment in question, and the retaliation can occur either during the employment or after the employment. The key things to look at are in Section 75B2A, which is the substantive provision that bars retaliation. The public employer must not dismiss or take other adverse personnel action against the public employee because the employee discloses, present tense, reasonably believed in proper governmental action, among other things. And the connection there is with the public employee definition, which is the respondent's focus on the present participle of the word holding. The key there is that when you distinguish the present participle and the present verb in those contexts with the types of personnel actions in 75B1D, it's clear that the temporal limitation refers to when the disclosure is made. When the whistleblowing occurs, it must occur during public employment because of discloses. It makes sense that that wouldn't apply to the personnel actions that are protected from retaliation because they include a number of words that are not specifically time limited in the statute and include circumstances wherein a person can be retaliated against after they leave their employment.
Are there other statutes that have been broadly interpreted to support that argument?
Yes, Your Honor. This court in particular in the Schmidt case interpreted a statute, the New York City Human Rights Law anti-retaliation provision that this court explained did not neatly cover former employees, but nevertheless the interpretation where it wouldn't otherwise be inconsistent, it was appropriate to protect public employees, to protect former employees, excuse me, in order to ensure that a quote-unquote parsimonious literalness did not cause gaps in the statute when this state places an enormous priority on protecting people from retaliation.
Counsel, was your client ever told why the offer from H&H was rescinded?
No, he was not, Your Honor.
Did he ever ask?
I don't know, Your Honor.
The question came from that way.
Oh, excuse me, I'm sorry.
That's terrible.
Mixture of microphone noise, I apologize.
It's okay.
Straight ahead.
So
So there was he was given no, I guess what I'm trying to figure out is he was given no explanation and he didn't ask for an explanation.
no, on top of that, Your Honor.
And your factual basis for saying that it's retaliation was he heard somebody else was retaliated against.
And on top of that, Your Honor, the other thing to look at as far as the reasonable inference is that his supervisors blocked off his ability to communicate with his other former colleagues at DOB. He was promised favorable references.
Yeah, what do you mean by that? He was blocked from, like, what does that mean?
He was told
Not to speak to anyone else?
He was told not to speak to anyone and indeed heard, may I finish answering your question?
Yes.
And indeed was told that others were barred from speaking to him.
By the others,
Correct.
by people he tried to speak with, in other words.
Yes.
And he had been given the job, and then it was taken back after a point where they started to do background checks.
That's correct.
DOB. Okay, thank you.
May it please the court, my name is Jameson Davies for the respondents. This court should affirm Supreme Court's decision to dismiss the complaint on the sole remaining argument that Mr. DaCosta raises. And I'd like
So,
to...
counsel, your position seems to be that the Civil Service Law, Section 75B, doesn't extend to post-employment actions, but the purpose of it is to prevent retaliation and retaliatory claims. So why shouldn't it, relate to also post-employment actions? Why shouldn't they be actionable when we look at other comparative statutes? There's an expansive reading given to, for example, the New York City Human Rights Law and other laws that are there to protect employees from this kind of retaliatory behavior. Title VII, the American Disabilities Act. I mean, they're all, to be read expansively. So why shouldn't we do that here with regard to this?
Sure, Your Honor. Two responses to that. First, and the most critical response is the text of the statute. The text of the statute here is much different than the text of those statutes. And I'd like to tee off with my colleague's quote from the statute because he skipped over some of the language that we think is key. He said, it says a public employer shall not dismiss or take other disciplinary or other adverse personal action against a public employee regarding the employee's employment. That's the language he skipped. And that language makes it clear that has to be regarding the employee's employment with the
But
agency.
again, as my colleague just said, we have expanded that in other contexts. And the question again to you is, why should it not be expanded here in order to fulfill the very purpose of the statute, which is to prevent retaliatory action?
And I would say that the reason for that is that the text of the statute, while it does protect employees against retaliatory action, it's not a human rights law the same way the New York City human rights law is, and two, it's worded much more narrowly. So the New York City human rights law provides that it.
So you're saying that an employer of the city cannot engage in this conduct while the person is an employee, but the moment they're not an employee, I can go to town and retaliate to my heart's content and prevent you from having a career ever again. Is that what you're saying? That's how we should read this statute?
Well, Your Honor, I think the text of the statute does compel that reading, and I think, but
did you just say that?
I'm sorry?
Did you just say that the statute compels the reading that we should permit the city to defeat the very purpose of the statute, which is to prevent retaliatory action? Because in essence, then, what you're saying is, by coincidence, this plaintiff loses a job offer just at the same time that the agency who's about to hire him is doing a background check. That's just by coincidence, right?
Well, a couple things, Your Honor. First, the background check could have revealed any number of reasons that H&H decided not to hire him. There's no indication of what was done in the background check.
Did something happen with this employee during his tenure at your agency that would have flagged him in that way, other than losing his job with your agency?
Flagged him in what way, Your Honor? I'm not sure I understand.
I think you do understand. Is there anything that you are aware of that happened with this plaintiff since your agency hired him that would have created a basis for him not to be a qualified applicant?
I don't believe there's anything that happened at our agency, but again, we don't know the content of H&H's background check or it's only alleged in conclusory terms the reason why he wasn't hired. And I want to...
So it's a coincidence that after they gave him a job offer and while checking his background with your agency, that all of a sudden it gets rescinded?
Well, I'm not sure that the background check was just limited to DOB. I think it was a comprehensive background check, or at least he just alleges that it was a background check. It's unclear.
Well, his background was good enough to be hired by DOB,
That's my
another
point.
agency of the city, and now he's looking to be hired. They actually hire him at another agency, and then when they start the background check, it's rescinded.
Yeah, that is correct. I think it's just that there's nothing but conclusory allegations regarding causation.
But look, how is the plaintiff, other than to say, well, there's a reasonable inference under the circumstances that there was retaliation, how much more can plaintiff say? It's not within plaintiff's keen, correct? So all he can say is an inference, and then discovery will essentially rule one way or the other as to what the reason was. Maybe there was no retaliation, maybe there was retaliation.
I think as to one of the justices' points, there was no indication that he made any inquiry as to why he didn't get this job. But I think really the clearer point is...
What does that matter at this stage? We're talking about the pleading stage. So the first issue is, do we extend the statute? And the second is there sufficient for it to go forward, right?
That's correct, Your Honor. And I think the more important and the stronger argument here is the statutory argument, because he never addresses regarding the employee's employment language. He never says...
But it is regarding the employment. The conduct occurred while he was employed. So it's not really outside the statute when looked under that prism, correct?
The whistleblowing took place while he was employed. That's what he alleges. But the statute says the adverse personnel action, which here he's saying is DOB's action, has to regard his employment with DOB. That's what the statute says. The action was not regarding his employment with DOB.
And that's why we suggest an expansive reading.
Yep.
Thank you.
I just want to make a couple additional points, assuming that there are no questions that I need to resolve. So regarding the language in the statute regarding the employee's employment, of course, that necessarily means that the whistleblowing has some relation to the person's job performance or their agency or something in that nature while they are presently there. If two people got into a fist fight at a basketball game while they both worked at the Department of Buildings, certainly that would not relate to the employee's employment. The other thing I need to point out about reading out of the statute is that respondent's interpretation reads out of the statute completely multiple examples in the definition of adverse personnel action that are incorporated, including appointments, reinstatements, and evaluations of performance. And the term evaluation of performance, while it might in a normal circumstance refer to a job reference while a person is presently in that position, there's nothing about the way that the statute is written that contemplates that an evaluation of performance can't include a job reference after leaving employment. And in addition to that, it's simply impossible to be reinstated to a position while you are currently in it. And in addition, appointment, as another example, which is distinct from promotion in the statute, necessarily means that you are awaiting to be appointed to a new public employment position. Now, there may be a situation in which you are currently in a public employment position, awaiting to be appointed to another, but there's nothing in the statute to imply that it's limited to that. The last thing I would say is with respect to the clear inference of the pleadings, DOB was his most recent employer. I think it would be inappropriate to say that that's not a sufficient reasonable inference, given that they were his most recent employer who had constructively terminated him due to his report to his direct supervisors, and he had been excluded from receiving references from anyone else because they had been barred from communicating with him. Unless there are any other questions, we'd ask that you reverse.
Thank you.
Thank you.
Thank you both. CBG Janovic Management versus Massachusetts Bay.
Good afternoon, Your Honors. My name is Craig Blumberg. May it please the court, I represent the appellant in this matter. This appeal arises out of a collapse loss to a suspended ceiling on November 28, 2016.
Counsel, you're seeking from the insurance company payment of rent that you paid during the period where the space, the store, your client is seeking, obviously, where the store space was unusable. In fact, the city had found that it was not usable, right?
Well, it's how the payment of rent is calculated into the loss of income claim. So it works out that, yes, we are seeking to, what we're saying is.
You paid the rent for a place that was demised, and you're seeking the insurance to reimburse you for that rent that was paid.
Well,
And you're relying on the sections in the contract, are you
That's
not?
right.
Okay, so under the lease, there are two sections, and you seem to be reading one of them as suggesting that you do get this rent. And I think it's the difference between 9E and 9C. But doesn't 9C require you to, that you don't have to pay rent if the property is completely damaged?
Well, 9C says that you don't have to pay rent if the property is totally damaged or rendered wholly unusable until the landlord.
Let me stop you there.
Because the city has already said that it's unusable.
Do you concede that it was at that point unusable?
It wasn't that it was unusable. They had to fix the premises to open up their business. So they still
couldn't use
occupied
it. You couldn't sell paint. I think you sell paint in there, right?
They could not open the store.
Okay,
Right.
so it was unusable, correct?
That's right.
So it's totally damaged?
It was partially damaged. It wasn't totally damaged. It was only the drop ceiling that was damaged.
Well, it's totally damaged. You can't use your space. You can't use it to sell paint and all the stuff you folks do, correct?
That's right. But the distinguishing factor here, the most important factor is it was the property of the tenant that was damaged.
But so what? The 9C says nothing about
Whose
the
property,
cost of the
yeah.
damages, right? It just says rent ceases if premises are totally damaged.
Only if it's the landlord's responsibility to do the
Says that in
repair.
9C? Can you point out the language in 9C that
Yes,
supports that?
where it continues, additional rent shall be proportionally paid up to the time of the casualty and thenceforth shall cease until the date when the premises shall have been repaired and restored by landlord. And the reason for that is that if it's damage to the building where the landlord has to do the repairs, then you don't have to pay rent. But this is no different than if somebody broke into your store and you couldn't operate your store, you still have to pay rent. The mere fact that they couldn't operate their business doesn't mean that they're not obligated to still pay rent. And that's why they were
But this idea that it's to the entire building, I'm not sure it's consistent with 9C, because 9C talks about the demised premises, correct?
That's right.
And so, let me finish. So the demised premises, it's not the entire building, it's the space that you've leased.
As long as it's the landlord that has to do the repairs. That's why 9E is in place, because that requires that the insured have insurance to repair their improvements and betterments and the suspended ceiling.
Another way of reading that is, hey, if something is damaged that's your property, you better have insurance for it. Isn't that a more reasonable understanding of what that provision is?
Well, no, I don't think so. I think that it differentiates what improvements and betterments are as opposed to the building itself. And I'll point out that the 309 Bakery case, which was my case, was the exact same thing. It was the exact same facts, and it was deemed by this court to be a question of fact. The mere fact
I'm not sure about that, counsel, because 309 Bakery Corp., there was an issue of fact as to whether the premises were totally damaged or rendered totally unusable. And here, we know, there's no dispute. The city closed the store. There's no issue here. 309 Bakery, there was an issue as to whether it was totally damaged. Here, no issue.
Well, that's
Store's closed. Can't do business.
well, that's not truly the case, Judge. I mean, that's why I attached the lower court's decision in 309 Bakery. But
You realize we have all the papers on that when we do the appeal,
I
right?
understand.
Okay, I just want to make sure you understand that.
I understand.
We have the ability to pull up all of the papers
Well,
on a prior appeal.
I did it for the.
So there is nothing you can say.
I have it
that
here
we
too.
cannot look up ourselves.
Yes. I mean, there was an issue of fact there. Where's the issue?
If there's anything else, no other questions, I'll wait for my rebuttal.
Okay, thank you.
Thank you.
Good afternoon, Your Honors. Jeremiah O'Leary on behalf of the defendant respondent, Massachusetts Bay Insurance Company.
Counsel, should we be reading this differently? Your opposing counsel says that, well, landlord didn't do the ceiling, so now, you know, there's a different section we're supposed to be looking at because the damage was caused not by the landlord. Landlord's not going to repair it. It was the plaintiff's own work.
Well, Your Honor's questioning focuses exactly in on the dispositive issue that the trial court correctly seized on, and that is the nature of the property that's damaged, the cause of the damage. All of that is irrelevant to the issue of whether or not the abatement or excuse for paying rent is triggered. And Your Honor's pointed to the exact policy language that says if the demise premises are totally damaged or rendered wholly unusable. The Department of Buildings in New York City came in the day after this loss and condemned the premises. They could not use it. That is the ultimate dispositive issue here, whether the property is usable. It doesn't matter what caused the damage. It doesn't matter whether it was the building that was damaged or the improvements and betterments or the contents that were damaged. The Section 9E that appellant's counsel makes much about has nothing to do with rent abatement. It has to do with the respective parties' obligation to obtain insurance on different types of property. In a leasehold situation, contents are the responsibility of the tenant, and so the tenant obtains insurance, indemnifying them for the loss of those contents. The same with improvements and betterments. The issue of whether or not the building was damaged or the structure, or the drop ceiling that fell here, which was the loss that gave rise to this claim, is irrelevant to the issue of whether or not the premises is rendered unusable by that casualty. It's not what caused it. It's not the nature of the property. It's whether or not the casualty causes the property to be unusable, thereby triggering the abatement provision of the policy. As far as the two cases that are, and there are only two cases cited here, Your Honors talked about one, the Baker case, fundamentally distinguishable factually and legally. There was a fact issue, as Your Honors correctly pointed out, as to whether or not both the trial court and the First Department found that there was a fact issue in that case as to whether or not the premises was rendered wholly unusable. There is not such an issue here, and as a consequence of that, there's just simply no basis for the court to even disturb the trial court's correct conclusion. There's one other case that was cited by the plaintiff that I want to point out, even though it wasn't discussed, and that is this, the Mescalor case. Again, the same issue. This was a Supreme Court case out of Queens County, but again, it's distinguishable on the precise basis that the Baker case is distinguishable, namely that the landlord established that there was an issue as to whether or not the premises was uninhabitable in the wake of the loss. That is not the case here. In addition, there was an issue that the court pointed out that the extent of the damage could not be determined on the record before it. As a consequence, it denied the insurer's motion for summary judgment. That is not the case here. We have undisputed record. The plaintiff doesn't dispute in the form of an order of the civil authority, the building department, that says that this premises was rendered totally unusable. As a consequence of that, there was no legal obligation to pay rent, and therefore, any rental payments should not be taken into account in connection with the business income claim. Thank you, Your Honor.
Thank you.
Your Honor, just a couple of follow-up points. On the massacre case, in fact, that premises was totally unusable. They ceased operating their restaurant due to a fire, and the issue as to whether they were required to pay rent under the lease was a question of fact, and that's exactly what we're arguing here.
I'm sorry, what is the question of fact here? I'm not following. What is
I personally, it's my appeal, I'm saying we should be granted summary judgment. I'm saying in the massacre case, the court determined.
No, in this case, what is the issue of fact that should be sent down for discovery and
Well, I move for summary judgment also, so my appeal is for summary judgment. I'm not even arguing that there's a question of fact, but any question of fact that may exist would be whether, under the lease provision, The insured was, the tenant was required to pay rent.
But isn't that a legal issue that we have to decide? It's not really a factual issue. Factual issue would be, are the premises damaged, not damaged, that kind of stuff, right?
Well, I think it depends on the facts of the case. In other words, that's why I'm arguing that because there was no damage to the building that the landlord had to repair, preventing us from occupying the space.
The problem with that argument is that it's not consistent with 9C, which talks about the demised premises, which is your space. I mean, and I'm having difficulty getting beyond that.
Well, again, getting back to 9C, there's specific language in there relating to not having to pay rent until the landlord does the repairs. And that is not the case here. The landlord had to do no repairs.
Are you saying that in your client's lease, the demised premises is the building and not your leased space?
No, that's not what I'm saying. I'm just...
Okay, so if the demised premises is the leased space, then all it seems to me that provision concerns itself with is whether your demised premises, your leased space, is completely uninhabitable or not.
No,
and you're saying that the demised space in this contract is the building. And that seems to defy almost every single lease I have ever read.
I'm not even making an issue out of the demised premises. The only issue is who was responsible for doing the repairs. Otherwise, anytime there was anything that happened in a tenant's space, if they said, we can't use this space anymore, we're not paying rent. That's not the way it works. It's only if the landlord has to do the repairs themselves, preventing us from doing business. And it was not the landlord's repair. Our insurance company paid us to do the repairs inside our premises. The landlord never even submitted a claim because there was no damage to any of his property. Because we had to do the repairs ourselves, we had to continue paying rent. And that was discussed between the attorneys for the tenants, the attorneys for the landlord, and it was all agreed that they had to continue paying rent.
Did you get it in writing, that agreement?
Well, there's letters that are attached. I don't know if there was anything in writing, but there's discussions between the two parties, and they paid rent. Otherwise, they wouldn't pay rent.
Paid rent, according to the record, on advice of counsel, and under 9C, I'll note that the landlord has an option not to restore you to the premises. So it seems to me that much more was going on than the concern about rent. It was about restoration.
Well, the landlord can only cancel the lease if it's repairs that they have to do that they're not unwilling to do. The landlord can't cancel the lease because there was damage to the ceiling owned by the tenant. The tenant never wanted to cancel the lease. They had to do the repairs and reopen. But
Thank you.
Thank you, Your Honors.
Thank you both. Friedlander versus Jax Holdings.
Will please the court, Salvatore Campaccia, appearing on behalf of the plaintiff appellant, Robert Friedlander. Your Honors. Your Honors, this is a very straightforward case. It involves a unambiguous contract and agreement between the parties.
So your contract that you're talking about, or a series, it's an email, is that right?
Correct, Your Honor.
Is that the email you're talking about?
The emails that were forwarded between Friedlander, the plaintiff appellant in this case.
So what triggered the defendants to duty to pay you under the contract, as far as you see it? Pay you the $25,000, was it?
The closing, the $600,000 bridge loan facility that they received that was clearly was a convertible note.
So was that, since it was an email, there are no defined terms here. Is there any special meaning, or was the term closing defined?
It was, clearly it says, it states.
Obviously, I'm asking because opposing counsel is, I imagine, going to say that all of the money wasn't paid. So it was closing, but the convertible loan, the funds weren't fully paid. So that there was really the closing, it wasn't a closing.
Once again, the appellant is relying on the agreement itself contained in the emails where it says that he would earn his commission upon the closing of the bridge loan. It said closing. There's no other interpretation, there's no other agreement to contradict that.
Does it matter if plaintiff was terminated prior to the closing under these emails?
I don't think it matters whether or not it was prior to not. That's what the operating principle here is that the agreement said closing. There was a closing on March 28th, and that triggered the finder's fee, the payment of $25,000 to Mr. Friedlander. That was clearly the agreement. There's no other written agreement. There's no other evidence that the defendant has offered in any of its response that indicates it meant something else. It was a closing, and of course, the appellant relies on the Maris case that's cited in its appeal, where in that holding, it's Maris 171 AD second at 549, where it makes it clear that closing means at the time of closing as opposed to anything else. Apparently.
So in other words, Counselor, the argument that the defendant is making will be adding terms to the contract that are not present. Is that correct?
Yes.
Thank you.
And plaintiff will argue that it was, since it was only, they received there was 40% outstanding funding, therefore, conveniently, that's below the $500,000 pursuant to the agreement. But once again, plaintiff's position is that it was at the point of closing and also regardless of the status of his employment, because he was also fired, I would say conveniently, a day later on March 29th. And their position was that he should be, he's not entitled to any funding because he didn't raise that funding regarding that particular loan. But the agreement makes it clear that he didn't have to. It was either 10% on his, whatever he raised himself directly, and if they were to get $500,000 more in funding, he gets $25,000 because also, and this is in the agreement, that he was forsaking his compensation as as an officer in the company. Mainly, he was he was the chief marketing officer, so he deferred compensation. So this was clearly, an agreement, a clear agreement between them, between the parties, and they breached by not paying the $25,000 pursuant to that agreement. As far as the defense claims that there was no contract was established, well, we'll rely on the actual.
You have some rebuttal
the actual
time.
agreement itself.
Okay, thank you.
Thank you.
Counsel, the other way.
Oh, it's a long day already. Huh?
I'm going to try not to make it any longer, Your Honor.
We'll see.
Your Honor, Dan Moretti, Lamb and Corsi, Blandon Ford for respondent. Counsel just said this deal was contingent on him forsaking his compensation. There's a big part of this lawsuit that he's also claiming he's entitled to all of his wages here, all of his back pay. So Justice Love got it right and said, why don't
Counsel, let me ask you this. The agreement says, should the company receive investment of $500,000 or more, and that I'm not involved with, the company will pay me $25,000 on closing. So that's the only thing he's seeking summary judgment on right here, is that $25,000, right?
That's correct.
And there's no
That's my
dispute
understanding.
that the company received $500,000, and there's no dispute that he wasn't directly involved, so he's not seeking more on that piece of his employment contract. He's just seeking the $25,000. Where's an issue of fact here?
Well, Your Honor,
Contract?
I think there's issue of fact. First of all, I think as Justice Love pointed out, the $500,000 was not received at the time of the closing.
But it was closing.
But
It was, a closing is the only word we have to be
It says
concerned
upon
about.
closing, right?
Was this?
And did it close?
Was- yes.
Did Mr. Mazzola write in an email, this loan closed, right? He wrote it? Did he, are you saying your client's a liar?
No, Your Honor.
It closed?
You're,
It was 25 grand on condition in those circumstances where he wasn't involved. So what's the issue of fact?
Your Honor, the issue of fact, was there even a meeting of the minds? Did this constitute a contract?
Yes, on several emails, he agreed to the terms. Come on. We have said repeatedly that where emails confirm an agreement, that is enough.
Respectfully?
Okay, let me just ask, please, so that you can answer it all at once. The plaintiff sent the email, and on January 21st, 2019, Green replied, as Justice Manzanet is referring to. Per our discussion with Jack this morning, the below terms are approved. Then on January 24th, 2019, Mazzola responded, as Justice Manzanet is referring to. All looks good. All looks good.
All looks good, and then there's a but, and then there are a bunch of things in there in that email, one of which...
I do think it's important to call out, as we discussed, and there's some other terms, you will remain an officer in the company during the fundraising process, but he didn't do anything to get those funds, which is what Justice Scarpula referred to. Under the circumstances, the real question that you seem to be balking at is this word closing, but it's a closing. It closed. Nobody's saying it didn't close. That you didn't get all of the money, does that mean it didn't close?
Your Honor, if I just may respond to something he said, but then he indicated a bunch of things there. That one of which was he's going to remain an officer of the company, he's going to continue to fundraise. During that time period, that is not what happened. He was documented misconduct, severe misconduct, bad-mouthing the company.
Does the contract anywhere, or excuse me, these emails, say that if he's terminated for cause, this money is forfeited, for example?
No, but I think the understanding was between these parties, and this is why there haven't been exchanges of hundreds, if not thousands, of text mails and emails and messages and other documents or any depositions, and I think that's why the IAS judge said, let's have some discovery on this to figure out what the party's understanding was.
But normally, when we look at a contract, if there's no ambiguity, we determine the intent of the parties based on the language of the contract, correct?
I'm sorry, I missed that question.
We determine what the parties intended by looking at the language of the contract unless there is an ambiguity, correct?
Yes, that's
what
correct.
is the ambiguity here that we would resort to extrinsic evidence?
Well, I think there's an ambiguity in this, in that he was supposed to also be acting as a fundraiser for this company. Instead,
this provision specifically said, if I bring in the money, I get 10% of whatever I bring in. If I do not have anything to do with money that's brought in, I get $25,000. So it doesn't matter whether he was good at fundraising, and apparently he wasn't, okay? It doesn't matter, because you included in the agreement that he would get $25,000 of any money raised, regardless of who raised it. What's ambiguous about that?
Your Honor, as Justice Love said, I cannot reconcile these two affidavits here. There needs to be some discovery.
But again, Counselor, I'm sorry. We look at affidavits when there is an ambiguity. When there's no ambiguity in the language, as my colleagues have been suggesting, then we look at the contract language to make the determination.
Thank you.
Thank you, Your Honor.
Sir, you have 2 minutes. If you want them, you don't have to take them. I noticed you sat there for a little while.
Your Honor, I believe it's covered. I'll waive the rebuttal.
Okay, thank you very much. Thank you both. Gorman versus Gorman.
Good afternoon, Your Honors. May it please the Court, Scott Horn, counsel representing the appellant in this matter. It's our contention, Your Honors, that the motion court erred in failing to account for the husband's documented dissipation of marital assets in the very account that was the subject of this court's prior remand directive. Despite possessing only a fraction of the statements for the 55-month remand period, the wife has documented some $140,000 in unilateral withdrawals, most of which were transferred into an IRA and thus outside the marital estate. Now, we've documented these transactions with supporting citations to the record at pages 18 through 20 of our appellant's brief. This dissipation during the remand period was unaccounted for by the motion court, and we submit respectfully that this was error.
Counsel, what was the basis of our remand?
The basis of the remand was to calculate the value of the account.
It wasn't to correct an inconsistency?
It was an inconsistency between the decision and the judgment. So the decision, Judge Drager...
But only as to the value, whether the value should be assessed on the date of trial or the commencement. Wasn't that what we said?
That's exactly right.
We did not send it back to reopen the entire issue. Those were issues that had to be litigated at the trial. And if they weren't, those are gone. We sent it back for a very narrow reason. And it seems to me that your client attempted to expand our remand into a brand new, let's reopen the whole thing.
Well, I don't know if it's a question of reopening the whole thing, Your Honor.
Enough of it that we should engage after a trial in discovery all over again?
In the sense that reports statements for the remand period. So this court was concerned with this 55-month period and the difference in valuation between the beginning of that 55-month period and the end of that 55-month period. So if marital assets are dissipated during that 55...
No, counsel, that wasn't it. This court was concerned with the disparity between the judgment and the decision. That's it. Nothing in the court's decision said anything about the fact-finding about what the account was worth or when or whatever the trial testimony was about that. It was just to correct sort of like an error in dates from one document to the other. It said nothing about going back and reconstructing what was put in and taken out of the account.
But I guess that's the point, Your Honor.
Well, let me just ask you, do we all agree? Do you agree? We said nothing about that?
You said nothing about what the value was on the commencement date.
The judgment, the decision says value it at this date, and there's a mistake in the judgment. So
Yes.
go back and fix
Yes.
that. That's it. Correct?
Absolutely. No, I agree with that.
Didn't say anything
100%.
about anybody, right?
I agree with that 100%.
So this is now your whole new spin on it.
Well, no, Your Honor, because there was no prior fact-finding about what the valuation was on the date of trial.
Did you raise that issue in the trial?
Did
you raise that issue?
The issue of the valuation of the account most certainly was raised during the trial. The court made a determination of not the valuation at the time of trial, but the date of commencement. This court said that was wrong. We're going to send it back so you can do a valuation as of the date of trial.
No,
So
I don't think we said do a new valuation, did we?
It was a valuation of her share, yes, Your Honor. That's what the remand directive was, and so by definition, it would have to account for what happened during that 55-month period between the commencement and the trial date. So if there's a 55-month period where assets are just being pulled...
I think my colleagues have asked that question. Why wasn't this raised at trial? I still have not heard an answer to that question.
Well, I don't have an answer except to say that
So you want
it
to
was not
redo,
addressed.
so in other words, you want a redo of parts of the trial when our order didn't provide for that, correct?
No, Your Honor, because there was no fact-finding made at the trial with regard to the valuation at the time of the
Did you appeal
commencement.
that specific request, and did you ask for a new trial on those grounds?
No, Your Honor. What we asked for was that the judgment be vacated and that the valuation actually be pegged to the commencement date.
So in other words, there was
This
an
court agreed.
inconsistency, to correct the inconsistency.
To correct the error, Your Honor, in the judgment, which said that the valuation should be as of the commencement rather than the date of trial. So when this court had the trial record, if this court had the ability to undertake a valuation, it would have certainly done so.
Counselor, can you address the second issue here, and that's with respect to the shopping center and the court's determination, essentially, that you waived rights to that asset?
Yes, Your Honor. So the shopping center partnership issue is important to begin the analysis with understanding that the wife has been a joint owner since 1986. This is not a situation where it was the husband's property and the court awarded her 50% as a consequence of the divorce judgment. The divorce judgment said, you shall, quote, shall continue to own this as joint owners as they had since 1986. And what happened was, and I see that my time is up.
I'll let you answer.
If I can just answer the question. Thank you, Your Honor. So since the time of the commencement here, the husband has withheld 12 years of distributions from the wife. The judgment, the language inserted in the judgment unilaterally, I might add, said that if the partnership allows a conveyance or an assignment, then the parties can do it. And in this instance, what happened was that the partnership allowed it only under certain circumstances, one of which was an extremely broad release provision that was contained in the proposed assignment agreement. And also, it failed to provide the records to support the distributions that were being upheld. And when it went before the lower court acknowledged that my client's entitled to this before she signs a broad waiver and waives rights against everyone, including the husband as a partner, I might add, that she's entitled to this. And it wasn't provided for. And ultimately, at the end of the day, Your Honor, where the rubber hits the road on this is she ultimately signed the assignment agreement that was signed by the husband, and she did it on the deadline that the lower court required. And at a bare minimum, we respectfully submit that her shares should be in accordance with that executed first assignment agreement, and the award of counsel fees in connection with that particular discrete issue should be vacated.
Thank you.
Thank you, Your Honors.
Jason Advocate for the respondent, Albert Gorman. May it please the court, Your Honors.
Counsel, can you address the second issue that was raised with respect to the waiver of the LP interest?
Yeah, which is the RS Shopping Center interest, Your Honor. In that situation, the wife, after motion practice, eventually did sign a release, but then she notified the managing partner's company and said, but I did so under duress. So they were rightly concerned that by claiming that it had been signed under duress, that they needed a new release form signed at that point, because clearly the appellant was setting it up to challenge down the road that release. And then she refused to sign the second and third assignments that they had sent. The third one, by the way, just simply updated the amount of money that they're holding. It's a few $1,000s that they're holding that they're not releasing to either party pending the transfer.
How much money are we talking about?
Something like her 50% share of the money being held, which is money that is accrued over probably the last 4 or 5 years, is probably in the nature of about $5,000, maybe between $4,000 to $6,000, I think. We're not talking about particularly tremendously important asset. And I want the court to be aware that
counsel, I mean, that's the dividends, right? How much is the limited partnership worth?
I have no idea, Judge. It was never, in other words,
So
Judge,
it could be worth $100 million?
I guess in theory it could be. It could be worth $1 billion, but an asset that over time throws off maybe $1,000 or $2,000 of income a year probably is not worth anything, or very, very minimally. The parties had a lot more, of these limited partnerships. This, frankly, was not one of the valuable ones, but, and I think you can see from just the amount that it throws off, it's fairly negligible. At no point was, in this case, the respondent trying to prevent her, or I should say, take that back. The court awarded 50% to her. We weren't trying to stop her from getting her 50%. We tried actively.
I read somewhere in the record that the plaintiff here inherited some of the shares of this particular shopping center from her mother.
Yes.
Are these the shares that she is forfeiting?
No, Judge. She owned shares separately through her mother or father. Those are not at issue.
Okay.
And she owns those outright. She'll continue to own those. Those were never something that the respondent in this case made a claim to at all. So that is not the issue. It was funds. It was actually the partnership interest here was something that my client acquired for, I don't know, the silly background, but I've been involved in this case too long. The parties were introduced to one another through the person who ran those partnerships. So that's why the wife's parents,
Seems by litigating, they both have already expended the value of this asset.
Oh, my God, that is absolutely true.
It's usually
Her has cost us so much money.
Usually true.
Counsel, I have
there's
a
another
question. Now, with respect to the assignment agreement, now, the wife had conditioned her execution on additional terms that the parties didn't initially agree to, no?
I think, by the way, it's not the parties. My client, hands off, he
Gotcha.
didn't care whatsoever.
Understood.
Whatever the managing partner was asking, yes, he was fine with. The managing partner put in some additional terms, but they were non-material. They were all cosmetic. For instance, instead of releasing the general partner and the law firm, they actually put the name of the law firm in there in one of the drafts. They moved the money up a little bit. So every couple of months when there was another distribution, they increased the money so it wasn't 3,000, now it's 3,500. They changed that number in one of the assignments. It was cosmetic changes that she kept fighting over. It's 12 years on this case, and we're trying to get to the end. We don't want to have her waive her interest, but if the court hadn't done that, we'd spend another $50,000 fighting over this interest.
Counselor, can you address counsel fees? They appear punitive in this instance.
What was that, Judge?
Counsel fees, the award of counsel fees in this case.
They were sanctions, Judge,
Can
which are
counsel
always,
fees,
in a sense,
I'm sorry, can counsel fees be imposed as a form of sanctions?
Yes, Your Honor, under 130, under 130.1.
Did the court explain that in the decision as to why this was the appropriate sanction?
I believe it did, Judge. I believe they said that the motion that was filed to re-argue was in fact improper. So that motion was simply frivolous, and there was no basis for it. And in fact, what the appellant has done in this case previously, and in this instance as well, is filed repetitive motions. This was not the first time a court has sanctioned her for some legal fees for filing repetitive, wasteful motions. Frankly, we had requested more money because the legal fees that we expended were higher, and the court didn't award me everything that we were seeking. So, in effect, sort of both parties have suffered from these repetitive motions. And to some extent, Judge, since she didn't have a lawyer, and it was only the respondent who had a lawyer in this one, he's the only one who paid any legal fees prior to the order of that counsel fees. And, Your Honor, if you have any questions about the brokerage account issue, I'm happy to address those as well. I agree with some of the questions here that this was an issue that could have been raised in the underlying trial, was really not raised. It should have been raised on the appeal. It wasn't raised. This is a chance to have a do-over of the original appeal.
Thank you.
And, Your Honor, could I say just 30 seconds? Is that
Okay, go ahead.
This case has gone on for very long, as everyone knows. Faulkner once said, "The past is never dead. It's never even past." This case is an anchor for the parties to the past. They need to move on. The only way they will do that is if the court cuts that anchor, and if the court lets the parties not be weighed down in their past and to move forward with what's left of their life. Thank you, Your Honors.
Thank you.
Very briefly, Your Honors, with regard to the assignment agreement, Justice Kennedy had asked a question about conditional terms. There were no terms added by the wife upon the execution of the agreement. The agreement appears at page 901 in the record, and it's a fully executed agreement. There's nothing handwritten on it. She didn't change any terms. There was never any agreement. She didn't want to necessarily transfer the interest. She was perfectly willing to hold it in joint pursuant to what Justice Drager had.
But that's not what was called for, right, under the governing documents? It was supposed to be a 50-50 division, correct?
Well, again, no. So the judgment said you shall continue to hold it in joint, period. Should have been cut and dried. When it came time for the judgment to be executed, the language was inserted that broadened things, like if it's allowable. So now what's allowable? And what are they going to demand of my client in order to do something that she didn't even want in the first place? The language was put in there at the husband's insistence.
Can you address counsel fees, please?
Sure. Counsel fees, Your Honor, this court has already determined in the prior appeal that the husband is the moneyed spouse, that there is a vast disparity in financial resources. The original counsel fee award was significant in the original judgment, and there's no question that the husband is the moneyed spouse. The award of counsel fees here, particularly because the partnership interest should have never been forfeited under a waiver doctrine, clearly she should not have been sanctioned for bringing a frivolous motion. She actually should have won that motion, frankly. She did execute, ultimately, the assignment agreement without making any changes, no conditions, fully executed, and to the extent that they rely upon this transmittal email from a pro se litigant claiming that she signed it under duress, there is no duress defense when you're under a court order to do something. So at the end of the day, Your Honor, the award of counsel fees was not supported by, and I see my time is up, if I can just finish this point, that there was no fact-finding by the lower court to support the award of counsel fees, and even if there was, she should have won it on the merits, and she's clearly not the moneyed spouse in this relationship. If there are no further questions, I'll rely on my briefs. Thank you, Your Honors.
Thank you. Thank you both. High versus Reliant Transportation.
Good afternoon, Your Honors. My name is David Perisman, and I represent the appellant plaintiff, Priya Pai. A couple of things that I think are very important to say. First thing I want to say is thank God for videotape, because if there were no videotape in this case, what we would have was that fabrication that the defendant has come up with, and I'm doing this 40 years, and I've heard some fairy tales in my life, but that one was magical. That's right up there with Grimm and Disney. But thank God we had a videotape. And second of all, the question that I think that this case comes down to is whether a plaintiff who has the light in their favor, crossing with the crosswalk, defendant fails to yield the right of way, admits all of those things, belatedly, reluctantly, but it's admitted at this point, whether they can be comparatively negligent for not looking at something that even if they were looking at it, they would have had a max of 2 seconds to have reacted to and done something about.
And I think you missed that she was hit from behind, where that vehicle came from behind her.
Right over here. She's almost, we don't have the room, she's almost beyond the lane, outside the lane.
We've seen the video.
Tried to pull into, and thank God we have it from 2 vantage points, but the video isn't the greatest because of the rain. The way the defendant characterized plaintiff in this case as walking down with her head down, not looking, that's almost as good as the fabrication that the driver came up with, because it's just not borne out by the video. What is borne out is 2 seconds. The difference between this case and Quintavalle and Toma are specifically, one, video. We have video that shows us what exactly happened. Number two, Quintavalle and Toma do not stand for the proposition that a plaintiff must affirmatively testify to looking somewhere, despite the fact that it would not have mattered. In fact, in the decision itself, in Quintavalle, the court says, notwithstanding the Toma case, there are circumstances where a pedestrian with the right-of-way may not be held comparatively negligent based on an alleged failure to pay ordinary attention or exercise ordinary caution. For instance, and then the court points to, in the Quintavalle case, the Perez case, where they said there would be no comparative because he could not have avoided the accident, given his testimony that he noticed the car moments before the accident. And then the court goes into another example and points to the Hines case, which is a case that was rendered where Judge Manzanet and Judge Renwick were on the panel. It's important to point out that one of the things that I was busy doing for the past couple of days is to see how many cases there are that have decided these things. Hines, Judge Renwick and Judge Manzanet on that panel. Perez, Rozon, Judge Manzanet and Judge Renwick. Mamome, Judge Renwick and Judge Scarpula. And Kwok, a second department case. All cases where they found, you folks found no comparative negligence based on the fact that it was 1 to 2 seconds that the plaintiff had the opportunity to react, just like here. Also, Razone, Judge Manzanet, Judge Renwick. Bimud, Kotu, and Bokum, Judge Renwick and Singh, all said no comparative negligence and said nothing whatsoever about whether the plaintiff was looking. So it couldn't have been important. Forgive me for reading into what you wrote. Maybe I have no right to do that, but you certainly didn't write it. I think defendants' efforts to make these major points of Toma and Quintavalle, it's great. They gave it its own heading. They gave each one its own heading. The only problem is both of the cases exactly carve out the exception that we have here and don't even carve out the exception of the magic of video. And so I'll close, unless there are any questions, but saying thank God for videotape.
Thank you.
May it please the court, Gerald Ford for the respondents. Our position on appeal is very simple. We believe that
Counsel, what facts have you raised with respect to the emergency doctrine? That was one of the affirmative defenses that was upheld.
Your Honor, the defendants conceded that the emergency doctrine did not apply below, and we concede that that emergency doctrine is not a defense.
Okay. And after looking at the video, which we've all seen, what do you think could possibly raise an issue of fact?
Your Honor, I think a reasonable juror could conclude from watching that video that the plaintiff was not paying attention. She was not.
I'm sorry, let me stop you there for a second. Where did the bus strike the plaintiff?
Your Honor, I believe the bus struck the plaintiff from the side.
From the side and the back side?
And the side and the rear.
So she didn't have eyes in the back of her head, you would agree, right?
She was already more than half a way across the crosswalk, and he clearly wasn't going to turn the bus in front of her, because maybe she would have seen then. She could have protected herself even though he didn't see her. He turned behind her, or she, the bus driver was a she. She was trying to turn behind her. She's not a very good driver because she missed that part and clipped the plaintiff. But I mean, where was the plaintiff supposed to look? Behind her? Supposed to walk with her head behind her?
No.
I mean, what kind of affirmative defense are you going to support? Where are the facts to support any affirmative defense here?
Your Honor, it's our position that if the plaintiff had been looking straight ahead, she would have seen the bus stopped at the stoplight on the left side.
She had the right of way.
Yeah.
She did. She did.
She had the right of way. Pedestrians have the right of way, and they're supposed to. The driver is supposed to yield.
But
she's walking. She would expect someone even mid-turn to yield. She's beyond the point of even halfway. The person is coming behind her. She's supposed to turn around. What could she do?
Your Honor, under the Toma decisions, the fact that she had the right-of-way does not...
No, the fact that she has the right-of-way does not necessarily make a difference where you can point to some fact that she should have been aware of something.
Well,
He hit her from behind.
But Your Honor...
He hit her from behind.
If she had looked straight ahead, she would have seen the bus stop.
This is all completely
She doesn't have
speculation.
She doesn't have an obligation to stop and let the bus go in front of her. She doesn't have that obligation. It is the bus driver who must yield the right of way to the pedestrian in the crosswalk. This bus driver, Ms. Collado, decided, I'm not going to wait for you to be far enough away from my bus. I'm completing this turn, and she clips her from behind.
But Your Honor, the plaintiff has a duty under Toma to use her eyes to see what's in front of her.
Can't see what's behind her.
But when she's at the crosswalk, the bus is in front of her to the left. There's testimony from the bus driver that he had the left...
So you're saying she should have allowed the bus driver, a school bus no less, to make the turn in front of her when she has the right of way. What case stands for that proposition?
Your Honor, we're not saying that.
You are saying that.
She has the...
She sees the bus, so she's supposed to let her go by? She has the right of way.
But she has the duty, if she had looked straight ahead, she would have seen the left turn signal was on. There's testimony in the record that the left turn signal was on. That's at 191 of the record.
Did the bus driver have a legal obligation to wait for pedestrians to complete their... Counsel, I need you to answer my question.
Your Honor, we're not... we don't...
You apparently are, because she has the right of way. You seem to be ignoring that fact.
I'm not...
A driver has to wait until all pedestrians cross in the crosswalk before completing their turn. Did this bus driver do that?
No, and that's why we were found liable on the plaintiff's motion for summary judgment on liability, which I'm not contesting.
Counsel, you seem to be thinking that automatically in the law that a driver, once they're found liable, they automatically are eligible for these affirmative defenses. That's not an automatic. It seems to be, that's the only thing I can think, based on these facts, based on the ridiculous, absurd testimony of your client. I just can't, it must be because you think that you're automatically entitled to an affirmative defense. It's just not so. Thank you. Thank you both.
Your Honor, could I answer that question?
Do you have rebuttal? Thank you. People versus John Atterbury.
Is it? Or do I have it wrong?
I have it here anyway.
Sorry that I got it wrong.
No, it's okay.
You're right.
Right. Thank you, Your Honors. May it please the Court, my name is Amy Donner, and I represent Appellant John Atterbury. We're seeking merely a small reduction of PRS from 7 to 5 years when Mr. Atterbury is
Isn't
already...
Mr. Atterbury the precise type of defendant that requires the extra 2 years here?
Actually, Your Honor, I'm glad you asked that because no, it turns out that he's done, well, first of all, he is already being monitored, obviously, by sex offender monitoring unit for the rest of his life. He has to have his home address and his photo, you know, on the internet.
Was he being monitored after the first incident that involved a different niece?
No, Your Honor. No, Your Honor. This is his first experience of all this stuff. And getting to Your Honor's first question is that he's done now extensive sex offender treatment, which he finds very helpful, and he's you know, he's has a lot of stability. He's already he's had no problem. He's had no violations on PRS. He's working. I just spoke to him yesterday. He's working over 40 hours a week. He's living with his son because under PRS requirements, they don't approve where his wife's address. So he has to live with his son. And his job is working as a cable and lighting technician, like setting up equipment for shows.
Counsel, I just have a question because defendant, when he committed this offense, against his niece, who I believe was under 13, right?
Yes, Your Honor.
He had a job then. He had, strong relationships with his family. I think he was age 50. So that certainly didn't deter him then.
But he does now have the sex offender treatment, and he's had no problems while he's been on parole. But if anything, and he will be, with the minimum, he still will be on PRS. It's still a 5-year PRS. And meantime, if anything, PRS interferes with his it's supposed to be for smooth reintegration into society. But if anything, PRS interferes with that because he's subject to the whim of this parole officer because there's a curfew of 9 p.m. and if he's setting up for shows, he has to always, be in touch with his parole officer constantly about his work hours. So he's subject to that. It would be more stable if he could live with his wife. In the meantime,
And the reason he can't live with his wife now is because the location is what? Around too many children?
apparently it's not, it must be within 1,000 feet of a school because that's the requirements for PRS. But so since he's already being monitored by the sex offender chief, oh no, so he can't visit, his daughter lives in Puerto Rico, he's not allowed to visit out of state, he has to constantly tell the parole officer if he's not gonna be in his own bed that night, you know, so he's subject to the whim of the parole officer, and that would be, whereas it just interferes with his reintegration into society when he's already being monitored for the rest of his life.
Well, it apparently is not interfering with his reintegration to society because he has a job, he continues to have a relationship with his family, he obviously has a relationship with his children and his wife, although he cannot sleep in the same place with her. There's always the option that they can move to some place where that is not a problem. So I don't see how it is interfering with his reintegration.
Well, it interferes, Your Honor, with his ability, in terms of his job, because first of all, he and his son are living in a studio apartment. So, but concerning his job is that, and the places that are not within 1,000 feet of a school are very far away, like in Far Rockaway. His job is like setting up for entertainment shows at night. And that does interfere because it's a
It sounds like what you're saying is that it's inconvenient, but sometimes, I mean, that sounds like what it is, it's inconvenient for him, not that it's, you know, causing tremendous, you know, problems. Anyway, you have some rebuttal time.
Yes, Your Honor. Thank you very much.
May it please the court, Amanda Regan on behalf of the people. As Your Honors appear to recognize, what defendant is essentially asking for is for his life to return to normalcy in the way it was before he committed multiple sex offenses against his niece and another niece that the count was dismissed because the statute of limitations had run. But defendant's term of 7 years post-release supervision was entirely appropriate and is not excessive. His criminal history and his actions in the instant case amply demonstrate why 7 years post-release supervision is entirely appropriate for this defendant. Not only was this defendant, there was the count that was dismissed for a summer 2008 sex offense, there was also the plea in 2009 in Bronx County, and the facts underlying that were also a sexual abuse of a third niece. So clearly this is a pattern of behavior of this defendant which demonstrates entirely why he is deserving of post-release supervision. And just briefly to touch on the Less is More Act that was discussed in the reply brief, clearly the legislature had a strong legislative intent as to why it carved out sex offenses as being subject to quote-unquote non-technical violations. And any other argument made by a defendant are simply speculative at this point in time, because the reality is we don't know how the language regarding these non-technical violations will be interpreted. And defendant still stands to benefit from many other aspects of this legislation. He will benefit from the earned time credit. He can benefit from the decrease in time between when there is a violation and when a hearing will be held. And there is also a new provision within the Act that provides for appeals of these non-technical violations. And because defendant appears to be doing well, this shouldn't be a concern for him at all. And so we ask your honors to affirm defendant's sentence.
Thank you.
Thank you.
First of all, Your Honors, less is more, as I explained in the my reply brief, is very different, and it has far fewer benefits for people who are sex offenders, and again, who is being monitored for the rest of his life with his photo on the internet and all that stuff. There's a lot of monitoring already. And also, my adversary points out, refers to things that aren't in her brief and came up with a third niece. I don't know. It's a lot of stuff that just off the record and nowhere. So it just, I would urge this court not to. I mean, it's just off the record and I'm not sure what that is. But anyway, he certainly doesn't need he's doing 5 years. He's an older man. He doesn't need to be subject to going to a parole officer once a month, and it just interferes with his reintegration into the community for the reasons that I said, because certainly it's much more stable if you can live with your wife, if you don't have to worry about getting in contact with your parole officer. He was telling me how her phone was broken. He couldn't even reach her for a while. You know,
Thank
things
you.
like that.
Thank you.
So thank you. For all these reasons, I respectfully request that your honors reduce his PRS from 7 years to the minimum of 5 years. Thank you very much.
Thank you. Thank you both. Oops, what did I do here? Okay. Liberty Mutual versus Jenkins Brothers.
Good afternoon, Your Honors. May it please the court, Michael Garvey, Simpson, Thatcher, and Bartlett, on behalf of Appellant Liberty Mutual Insurance Company.
Good afternoon.
The lower court's summary judgment ruling defied Insurance Law 3420. Insurance Law 3420 permits tort claimants to recover insurance proceeds from a dissolved tortfeasor's liability insurers.
Would the rule be different if Liberty Mutual was a real party in interest here? Could there be a direct claim against Liberty Mutual under those circumstances?
Respectfully, no, Your Honor.
So you still think the statute requires a judgment against Jenkins before you can proceed against the carrier?
Before the statute is categorical on this. Before tort claimants have standing to proceed directly against Liberty Mutual, they need to obtain a judgment and wait the 30 days. That's right, Your Honor. Now, the real party in interest reference that the lower court made below was a reference to a case called Germain. In the Germain case, a prior set of asbestos claimants sued Jenkins, the dissolved tortfeasor, and argued that they should be allowed to effect service of Jenkins on Liberty Mutual. And the court, in allowing substitute service, held that Liberty Mutual was the real party in interest. But the Germain case, of course, didn't conclude that Liberty Mutual forfeited all of its coverage defenses. In fact, the Germain case was actually explicit that any liability of Liberty Mutual would be determined under 3420, namely dictated by the scope of coverage
under the Liberty Mutual policies.
So Liberty has been paying for all of the other claims, obviously, for years. There's no other insurance company because it seems that in 1980, it's when Jenkins started to encounter issues. So there is no other insurance company. Should Liberty be at this point, and I know a new management company came in and reassessed how they should be paying for this and this pro rata basis, shouldn't they be judicially stopped from being able to change from paying all of it to now paying in this pro rata way?
So respectfully, Your Honor, no, they shouldn't. And I think my opponent mischaracterizes the record a bit to suggest that Liberty Mutual was paying 100% of settlements for many years. That's actually not true, and I'd refer the court to footnote 2 of our reply that sets the record straight. But the key issue, and it's to some degree a red herring, I think, in this case, because the key issue in this case are these 9 claimants, right? And these 9 claimants have no visibility into what Liberty Mutual did in any prior cases involving prior tort claimants. Those prior settlements were all confidential. These 9 claimants were told explicitly by Jenkins' defense counsel at the direction of Liberty Mutual what amount Liberty Mutual would fund consistent with its obligations under the Liberty Mutual policy.
And that there would be this orphan period, or that whole thing was explained to them, you're saying?
It was explicit to them before they entered into settlements.
Was that ever communicated to the court that these cases were pending before so that the judge knew that this issue could come back? I mean, as a trial judge, you want to make sure that your settlements stick. So if you're going to have this kind of situation, I don't know, I would have, as a trial judge, wanted to put that on the record so that this would not happen. So was the court aware of the nature of these negotiations, that they were settling, but
yes.
between lawyers?
So the short answer is yes. In the underlying asbestos cases, the settlement agreements between these claimants and Jenkins, the dissolved tortfeasor, are explicit that only a portion of the settlement amount is being funded because Liberty Mutual is the only show in town, and Liberty Mutual had agreed pre-settlement the amount that it would fund. So that's in the actual settlement agreement between claimants and Jenkins.
Right, but was the court a part of those settlements? Because if there's a settlement between attorneys and paperwork is exchanged outside of a court setting, the court doesn't know what you both agreed on. You report to the court that the case is settled, we're happy to record it. My question is, was the court aware?
Yeah, so I am not.
At the time that the settlement was
I follow your question.
entered into, right? So that the court now says, okay, that case is settled, wonderful, settled. Was the court aware of this arrangement? Because typically a court doesn't get a copy of settlement agreements unless an infant is involved.
Right, so I think you're right, Your Honor. I think that the court that was presiding over the underlying asbestos cases, which was not Justice Sengoron, it's a different, as Your Honors are aware, it's a whole different docket, isn't a party to that settlement agreement. That's right. But when the coverage issue was raised before Justice Sengoron below, of course, Liberty Mutual.
Yeah, but by then the settlement had already been taken, right?
Right. But Your Honor, I would note that this happens all the time in asbestos settlements and other tort settlements where the underlying tort suit is resolved, but there are still coverage defenses that need to get litigated.
It's just usually it's pro rata between the insurance companies, right? It's not between, here there is no other insurance company. So it puts the settlement in a...
That's true, Justice Renwick. The more classical example is there's another insurance company or there's a live policyholder, and here we don't have one. But the concept is the same, and there's no prejudice to these claims.
Can you cite to any cases that uphold this pro rata share that did not involve insurance companies? Because I've always seen it in that situation, in that landscape.
So It's a good question, Your Honor. First, I would note, as a matter of practice, insurance companies all the time apply pro rata allocation in this context, including with dissolved policyholders. The fact of the matter is, no one until now, no claimant until now, has made the argument that for some reason claimants should get broader coverage than Jenkins would have been able to had Jenkins been around. And that, of course, violates the core principle of 3420, as Chief Judge Cardozo said back in 1927, claimants can't get any more and they can't get any less than what Jenkins could have gotten under the policies, and that's just the law. I see my time's up. I'm going to be back on rebuttal. Thank you, Your Honors.
May it please the court, Alex Shugsta from Cohen, Ziffer, Frenchman, and McKenna, arguing on behalf of the individuals, their surviving family members, and their estates, who are referred to in this case as the asbestos victims.
Counsel, can you address the last point raised by your adversary with respect to why pro rata allocation is appropriate here? Because, in effect, your clients are essentially in the shoes of Jenkins. They get no more, no less than what Jenkins would be entitled to.
Well, Your Honor, quite simply, the underlying rationale for pro rata allocation has absolutely no application on the facts here. Pro rata allocation has only ever been applied between an insurance company which made a decision to sell insurance and accepted premiums to a company that...
But in effect, aren't you asking for insurance coverage for periods where Liberty Mutual was not insuring Jenkins?
Your Honor,
Wouldn't that be the result, yes or no?
Well, yes, but here's why this is different.
And how does that make any sense?
It makes sense, Your Honor, because one of the reasons, and I think Your Honor is very astute in following this path, one of the reasons that is argued against pro rata allocation is that it would result in a windfall for the policyholder because they're getting coverage for periods in which they didn't purchase insurance. That is 100% absent from this case. The victims of Jenkins Brothers' tortious conduct are not receiving any windfall in this situation. As a matter of fact, what they're doing is they are losing money that everyone agrees that they are entitled to, including Liberty Mutual. Which
well, but if Jenkins was still around, presumably Jenkins would be responsible for that essentially 1/3 share, right?
If Jenkins was still around, that's correct. But with Jenkins gone, the only two parties who there are to allocate responsibility here are Liberty Mutual, which was involved in this situation voluntarily by having sold insurance, and innocent asbestos tort victims who had no involvement whatsoever.
What if this was not a third? What if it was, that there was 60% that wasn't covered? Would Liberty Mutual be expected under those circumstances to pay the remaining 60%?
Yes, Your Honor, under the facts of this case in which Liberty Mutual paid that 60%, or in this case 30%, actually for each of the claimants it's a little bit different, but where Liberty Mutual itself acknowledged that that's its obligation by paying those settlements in full until it arbitrarily tried to take a swing at imposing.
You're arguing judicial estoppel, but I don't think that applies here.
Yes, one of the bases for the trial court's decision was estoppel, but what I'm arguing is that Liberty Mutual's course of conduct informs how this is supposed to be handled in this situation where you have a dissolved policyholder.
But these are completely different claimants, right?
They're different claimants, Your Honor, but I need to stress there was no difference in the facts or the law of these victims where Liberty Mutual arbitrarily decided we're going to start paying less than 100%.
Well, but they were told, right, that with your clients, they were told this is what we're doing, right? We've relooked at all our policies. We've looked at Keyspan in 2018. This is what we're doing. And there's no doubt that this was not a surprise.
The fact that a violation is told in advance and is not a surprise does not excuse the violation.
What do you mean a violation? What violation?
Here, they're trying to graft an inapplicable doctrine to reduce the amount of the settlements with the asbestos victims. The fact that
That's
they
what
just...
plaintiffs have lawyers for. They didn't have to sign and agree. They could have gone to trial, as your adversary points out in his brief.
Well, Your Honor, what the plaintiff's lawyers did here was exactly right. They said, we agree this is the right settlement amount. We understand you're only going to fund a portion of it. We do not waive any of our rights to pursue that other portion. And as a matter of fact, that's why we're here. Liberty Mutual commenced this lawsuit because they knew that the asbestos victims were going to bring claims against them for the unpaid portions of their settlements that they didn't waive any rights to. So this was actually the exact right way to handle it. Get the victims the money in hand that Liberty Mutual was offering, and then litigate over the difference between what Liberty Mutual disputed its obligation to pay and what claimants believed they did have enough.
So your argument is the course of conduct? It's not judicial estoppel, it's that because of their former course of conduct, they should have to do the same thing, even though they articulated the difference and that they were going to be handling this case differently than the past?
With respect to Your Honor, it's not either or, it's both. And the lower court was clear on that.
Okay, course of conduct and judicial estoppel is what you're saying. You're arguing under both.
And the fact that pro rata allocation, I'm sorry.
I'm just thinking with judicial estoppel, this wasn't a case that was, factually decided in court. This wasn't something that, they were proceeding and a decision was made in the court based on certain facts, and now they're changing their position, and, there's nothing that happened in court where a legal determination was made. This was a settlement.
Well, correct, but that was a settlement of a court proceeding that, happened in the context of a litigation. But, Your Honor, I think the important point is estoppel is one of the bases, absolutely, and it's one of the bases for the trial court's decision. We believe it's justified. But also, pro rata allocation is inapplicable to these facts. So once you take that away, they have no basis to go under 100%
And it's
anyway.
inapplicable because we're dealing with injured plaintiffs as opposed to Jenkins, is that, or another insurance carrier, or what?
That's correct, Your Honor, because the rationale under which pro rata allocation has been applied is completely absent from these facts. You can't allocate...
Isn't the rationale of pro rata application, correct me if I'm wrong, it's really based on the policy language. That's what the courts look to. And in this instance, isn't the policy language such that would support pro rata application?
Yes, the policy language here is the same as in those decisions in which pro rata allocation has been employed by the courts in this state. But that's not the only
Why should we deviate from that line of cases in this instance?
I see my time has expired, if I can answer the question. The reason to deviate here is because the rationale that underscores pro rata allocation is to divide responsibility for a settlement that's already been effectuated, that's already been paid, between parties that have, for lack of a better word, skin in the game, for parties that did something where they have some responsibility that merits allocation. Here, the asbestos victims did absolutely nothing to merit responsibility except show up to work. And so they didn't make a decision to not purchase enough insurance. They didn't make a decision.
But those are, it sounds like those are claims that you'd make against Jenkins, because it was Jenkins that didn't do this. It was Jenkins that was producing products that allegedly contain asbestos. It's not the insurance company.
Well, that's correct, and that's why, Your Honor, there is a basis. So once you strip away their rationale for paying less than 100%, there is also a strong basis in New York law for the fact that Liberty Mutual should bear this responsibility and not the victims. Under real party and interest, under the doctrine of indemnity, under estoppel, these are doctrines that the courts have used to hold a party that isn't the actual wrongdoer, which here was Jenkins, but Liberty Mutual made the conscious decision to sell insurance to Jenkins. There's a rational basis to hold it responsible, and by doing so, we ensure full compensation for innocent victims, which is the doctrine underlying all of those.
Isn't that more of a public policy issue, where we're saying that it's totally outside of the portion that Liberty was contracted for? I mean, this is because whatever the business plan of Jenkins, obviously it was asbestos gaskets or whatever it is, and they didn't have enough money to, get another insurance company when things started to unravel. They stopped paying on the insurance. The policy ended. Isn't that public policy issue? That remaining point?
But, Your Honor, I think in this situation, what the courts have looked to is how do we fully compensate the innocent victim and who's in a better position?
That's
who's
why I
here
go
for a
back to
reason.
the 60-40, not the two, what a third left, is that what if it was that, you know, there was 60% that wasn't covered, I don't know if that's realistic, but 60% that wasn't covered by an insurance company. Liberty would be responsible for that 60% over their 40? Anyway.
Well, Your Honor, I think, yes, they still would be responsible for that 60%, again, because the result we want to avoid here is having an asbestos victim say, with counsel appointed by Liberty Mutual, my claim is worth $50,000, and have Liberty Mutual slide over a check for $5,000 or $10,000.
Thank you. We understand your point. Thank you.
Thank you, Your Honors.
Thank you. Thank you both. Leung versus Madison Street.
Good afternoon, Your Honors. Michael Rasciuto of Friedman, Levy, Goldfarb, and Green for the plaintiff's appellants. Your Honors, the red string protruding from the garbage bag in question was not open and obvious, and therefore the court below should be reversed. Your Honors, this case involves a trip and fall on a red string that was used to tie a garbage bag.
What was the red string attached to?
It was attached to the garbage bag. It was a
Were the
piece.
garbage bags open and obvious?
Well, Your Honor, my position is that the string was not open
I
and
understand,
obvious.
but I'm asking you a different question.
The garbage bags were visible on the curb.
That's not what I asked you. Was it an open and obvious condition?
Your Honor, I can't concede to that point.
Okay.
You know, this court has held, in the case Mizell versus Bright Services, that garbage bags, there was a question of fact as to whether or not garbage bags were open and obvious when the plaintiff was actually climbing over them in a vestibule.
So, counsel, when I look at the, it's over here on the
Oh, I'm sorry. With the mess, it's so difficult. I apologize.
It's like ventriloquist.
It sounds like it's coming from over here.
No, it's weird. It really is weird. I mean, I look at the pictures. I see those red strings right there. How are you arguing that they are not open and obvious? It's not like we don't have pictures. We have pictures that the wife took, like literally right after the accident. I can see the red strings straight up. I mean, the ties for the garbage bags. I can see the garbage bags. I can see the red strings. How do you dispute what's in the pictures?
So, Your Honor, my client exited his apartment at 100 Madison Street. He turned left. He walks about a half block down. There's two people on the sidewalk in front of him, which causes him to veer to the right, closer to the garbage bags. The garbage bag in question, the photo is circled, the record at page 166, the string that caused his fall, is at perfect tripping height. This is not a stack of garbage
No, the question, you said it wasn't open and obvious. I looked at the photograph, it's right there. How could that not be open and obvious?
Your Honor, the strings are not open and obvious because they're down at the ground. He's looking in front of him. He's not observing these strings that are pointing inward. And Mr. Yan, who is the defendant's witness, conceded that the strings, if pointing inward, would be dangerous, and therefore he instructed Mr. Lee, the building handyman, to have all the strings facing outward for that particular reason.
And that string that was taken was parallel to the street. It wasn't in. You said that they're pointing inward, but they're not. I mean, the pictures say what they say. That's what I.
So the court below
say that, but the string in the picture is pointing parallel to the street. It is not pointing in.
Yeah.
So that hypothetical really doesn't go anywhere.
So, Your Honor, the court below said that the strings were perpendicular to the street. I believe that they were parallel.
No, I looked at the picture. They are perpendicular to the street.
Prior to my client's accident, the string in question was perpendicular to the street. It was sticking out. He trips over it, and it's not unreasonable to believe that the force of a foot tripping on a bag would cause it to move in the direction that he was walking, which is what the photo shows. When you look at the photo,
you're saying he was walking into the street, and that can't be. He's not.
No, Your Honor.
The string is parallel in the picture. And you're saying that it was somehow, it was perpendicular, and then when he moved, it went that way?
Exactly. Your Honor, I'd like to call to the court's attention the record at page 166.
No, I know, I can see, I saw them. It's
so my-
hard for me to see it from here to there, but okay.
Right, so it's difficult to see, I realize that, but Mr. Lung was walking from the top right-hand corner to the bottom left-hand corner. This
Counsel,
string
your
was
problem is in his EBT, he acknowledges that he saw the large black garbage bags on the sidewalk. So, and he says that he moves closer to the side to those garbage bags because other people were traversing toward him.
Yeah, he testified that.
So he obviously saw the garbage bags before he fell. He chooses to, instead of stopping to allow these people to walk by, he moves closer to the garbage bags. How does that make the defendant responsible?
Well, so it's not the garbage bags that he tripped over, it's the red string.
Yes, but the red strings are connected to the garbage bags. I mean, counsel, they're connected. They're one and the same.
Right, and this court in Ruiz found that that a protrusion from a garbage bag could be actionable, and Judge Kalish...
Well, that's a different kind of protrusion, but this is a small, the yellow loops, the red loops that go around the bag. Even from the picture, he's already tripped and fallen. We can't determine from that picture whether that red loop that's sticking out at that point was sticking out at the point where he fell or whether it was moved at the time he fell. And it's still, once you see the bag, I mean, the bag is an open and obvious condition. The loop is there. Anyway, I'll give you...
Your Honor, I see that my time is up, if I may briefly...
I'll just give you 10 seconds.
Thank you, Your Honor. So my client, Mr. Lung, clearly and unequivocally testifies that the red string is what caught his...
No, I understand. A red string caught. Yes, I understand that. But I'm saying in that picture is after he fell. I don't know that red string was sticking out in that way. That's what I'm saying.
Well,
one red string caught his foot. And after he fell, I imagine everything was moved around. The bags, maybe not. They're big, but the red string, that...
Yeah, I mean, it's a post-accident photo, Your Honor, so the court can't read into what this, that this is not what the scene looked like.
You're right, and I think my colleague spoke to the other issue. Thank you.
Thank you, Your
Let's
Honor.
hear.
Good afternoon, Your Honors. My name is Warren Koster from Koster, Brady, and Nagler, and I represent the respondents in this case, and I will be very brief. I ask you to affirm the decision of Justice Bluth. Our summary judgment motion was based solely on testimony provided by the plaintiffs, Mr. and Mrs. Luang, and on the photograph taken by Mrs. Luang shortly after the accident. Both Mr. Luang and Mrs. Luang testified that the photograph that Your Honors have referred to was a fair and accurate representation of the condition of the garbage bags at the time of the accident.
Counselor, how do you respond to the argument that we should be looking at the red strings and not the garbage bags, and the red strings themselves were not an open and obvious condition?
Your Honor, there was never any testimony that the red string that was, whether you use the word protruding or the words sticking out of the garbage bag, caused the accident. There's no testimony in the record that those red strings or that red string impeded the path of travel on the sidewalk of Mr. Luang. And if you look at the photograph...
But we do know, according to his deposition, that the red plastic tie caught his leg and he fell.
Excuse me, Your Honor?
The red string, the red plastic tie caught his foot and he fell. So we do know that. So clearly that's what happened. So why is that an open and obvious condition?
Well, it's an open and obvious condition because it's attached to the large garbage bags that he saw the moment he left his apartment building.
He's saying that the large garbage bags are just that, big, large garbage bags.
Right.
Looking at the large garbage bags, but the little string that his foot caught on is a little string. It's not a big black garbage bag. So
Correct.
We're saying that's not open and obvious. So
No.
what is your response to that?
Well, it's not a latent condition either. If you look at the photograph, it is parallel in the direction in which the pedestrian plaintiff is walking. And if you look at that photograph, it's hidden by the black bag. But that doesn't make it a latent condition. at all. And he says that he was walking 1 to 2 feet away from the garbage bags at the time of the accident. There is no way that he was in that position and that little string came out and caused him to fall. And one other point, a point that the lower court concentrated on, Justice Bluth said that he walked towards the open and obvious condition when he didn't have to. And there's testimony in the record that the 2 pedestrians who were walking ahead of him were on the left side of the sidewalk, and the other pedestrian who was standing on the sidewalk was also on the left side of the sidewalk. And the photographs that were introduced at the deposition of Mr. Luang show we're dealing with a broad sidewalk on Madison Street. There was plenty of room for him to walk unimpeded away from the garbage bags. And we would ask the court to follow its holding in the Ruiz case and affirm the decision of the lower court.
Thank you.
Thank you, Your Honor.
Your Honors, very briefly, I don't know if it was perhaps poor questioning of Mr. Lung or the fact that he was testifying through a Cantonese interpreter, but he was walking straight at the time of his fall to continue down Madison Street. And the only conclusion that can be drawn from the photograph, which the respondent seems to hone in on as well as the court below, is that that red string was sticking out in a manner that it caught his foot. And it was a hazard and a dangerous condition, and it was
Counsel,
latent.
if I may, but, plaintiff also testified that the bags did not block the sidewalk, correct?
The bag did not block the entire sidewalk. It was on the curb.
Sure, and then just to follow up on what counsel said about these individuals that he tried to pass, he also indicated that they were some distance away from him, correct?
Yes, and the testimony is that my client was 1 to 2 feet away from a garbage bag, which I think is a reasonable distance from a garbage bag. And if the tie hadn't been sticking out the way that it was, then this
Counsel,
never
I
would
know
have happened.
no garbage tag that sticks out 2 feet.
Well, Your Honor, I believe that...
After you have tied the garbage bag.
I think that Your Honor may be reading the testimony a little too closely. 1 or 2 feet from the garbage bags in general is what I believe Mr. Lung was testifying about, and that the subject garbage bag was sticking out further than that with the red tie right at perfect foot level. Thank you.
Thank you both.
Check. 1, 2, 1.